Welcome to this week's OK at Work with myself, Sarah Sawyer, and my colleague Russell Berger, both attorneys at Offit Kurman. And today we are talking about medical requests, whether it be in the form of an FMLA request or an accommodation request under the ADA, and kind of just some things that employers should be thinking about. Also, I've got clients that don't fall under the FMLA, but, might also provide unpaid leave of their own choice to clients or clients that, employees. So just want to talk a little bit about what are some things that employers should be thinking about when they are vetting these requests and going through this process, especially as it relates to FMLA and ADA. So what are some things that employers should think about when they are working their way through those processes?
Yeah, well, the first point is one you kind of made with your question is that multiple laws may apply, and it's not, just an ADA problem or just an FMLA problem. Um, Multiple, leave laws, accommodation laws, disability protection laws could all apply depending on your jurisdiction and the facts of the circumstance. So that's the starting point. Really, when you get a request, usually I'd say more often than not, it starts off as an ADA request, or at least the ones that start off as an FMLA request stay FMLA and don't find their way to us as the lawyers quite as often. But often, like the ones I see are come in as ADA requests, but could really spiral out into a lot of things. And what I'm a big proponent of is getting forms in front of the employee and their healthcare provider to fill out. Here's a formal request for information so that we can make informed decisions, so we can engage in the interactive process, which is required by the ADA, so that we can go back and forth and figure out what kind of accommodation, if any, is warranted in this circumstance.
Yeah, I'm with you, Russell. The forms is a great way to standardize the process and be ready for these requests as well. And just to be consistent and make sure that you're asking the same questions of employees when they have requests and staying on top of the process because it is a process. It takes time, takes vetting, getting through the process, trying to understand what the employee's need is, especially when it comes to an accommodation request. They might be requesting one thing, their doctor may make a different recommendation, and then the company might not be able to accommodate those exact types of requests. So really it's an information gathering exercise, wanting to get enough information, not, too much information that you wouldn't need for the process. We want to make sure we draw tight lines on that you're not asking questions out in left field that don't really actually matter and are more out of curiosity. I'll just flag that there. But wanting to get enough information to be able to really engage in the process, because that's what the employer's duty is to engage in the process, figure out what the need is. And forms, especially going through a doctor as well, are great ways to get that information in a delicate way. And giving themselves enough information to be able to work with the employee to figure out what the needs are.
Yeah, and one point I want to make about the intersection of these laws is if the person's FMLA eligible or a state version of that, um, and the accommodation is going to require leave, you want to make sure you're running that leave, you're burning off FMLA leave as well. So if someone needs to be out on leave, that should count on the FMLA clock as well, because that's 12 weeks of unpaid child protected leave in the course of a year. Um, and so you want to be able to not make an, if you make an accommodation for 6 weeks and then the person says, oh, I need leave. And then they take another, if you haven't been running the clock, you'd have to let them take another 12 weeks. So you want to make sure you're running these things concurrently and you're mindful of, the usage of both laws at the same time.
It's important both from a compliance perspective and just from an anticipating the needs of the organization perspective. So the clearer that you are able to be with the employee about how things are going to run, and getting the information from them about how much time they actually need, then the better off the company is and the employee is, both from a compliance perspective and just from a practical perspective, everyone being on the same page and planning when someone's going to be out and getting all of that information. Because I know a lot of my clients will lose time kind of as they're getting this process in place. So if you're not ready for when that request comes, because that request could come at any time based on the need of the employee, and those requests and the needs of the employee can change and adjust. If you're not ready and you don't have a process in place, you're going to lose time figuring out that process, because you need to, a good example with FMLA, like you need to mark it as FMLA before the employee goes out for it to really be able to count towards FMLA. So these things need to happen ahead of time. So you need to be ready. I mean, someone might have a need in a couple of days, or it might not be as much as you might want advance notice. It might not be possible. So being ready, having those forms ready, prevents you from losing time as well, where someone needs to go out, and you're still fumbling with the paperwork and trying to figure out the details.
That's right.
Well, thanks, Russell, and we'll see you next time.
Thanks, Sarah.